Namaste and welcome to Daily News Simplified, the what, why, and how of newspaper reading. Today, we would be analyzing the Delhi edition of the Hindu newspaper of 9th March 2018. Now, let us begin. Now, we've taken the lead editorial from page 8. Now, what this article talks about is the new mandate or the new perspective for the non alignment movement. So, what we'll do first is understand the conceptual timeline of the non alignment movement. And after that, we would analyze the focus of this article. Now let us first understand the conceptual timeline. Now the non-alignment movement began as an initiative to create an independent path in world politics by not aligning with either of the superpower blocs. Now after the Second World War, the international world order became divided between two superpowers, the United States of America and the Soviet Union. And both these blocs became engaged in an ideological conflict with the United States supporting the free market economic system and the rule of democracy, while the Soviet Union supported the communist system. And because of this conflict, world politics became divided into these two power blocs, with some countries aligning with the United States, such as UK, France, among others, while other countries aligning with the Soviet Union. And also after the Second World War, many countries in Asia, Latin America, Africa gained their independence, such as India, Indonesia, among others. And these newly independent countries did not want to be aligned with either of these power blocs and wanted to create an independent path, and for which they created the non-alignment movement. But in 1991, the Soviet Union collapsed and disintegrated into smaller countries, with the largest being Russia. And because of the disintegration of the Soviet Union, the earlier conceptual mandate of the non-alignment movement was not highly relevant in the new international world order. And it lost relevance because one of the two power blocs, which was headed by the Soviet Union, collapsed and USA became the only major superpower in world politics. And in 2012, as also highlighted in the lead editorial, a new policy called Non-Alignment 2.0 was put forward by a research think tank based upon the views of former diplomat, academic, and others. And Non-Alignment 2 focused on a new conceptual framework to revive the non-alignment policy of India in the new global order. Now, this new global order was actually the rise of India and China, and among other countries in Africa, Asia, and Latin America. And because of this rise, there was a shift in international politics, and within this new global order, the framework of Non-Alignment 2.0 recommended that India should maintain the policy of strategic autonomy in the new global order. And this policy perspective of strategic autonomy meant that India should not take sides in the new Cold War that has been emerging or is going to emerge between the United States and China. Now, hopefully, up till here, you have understood the conceptual timeline that is also highlighted by the lead editorial, that the non-alignment movement was created by the newly independent countries after the Second World War to create an independent path by not aligning with the two major power blocs that were formed by the United States and the Soviet Union. But in 1991, after the collapse of the Soviet Union, the earlier conceptual mandate of NAM of not aligning with the power blocs lost relevance, since United States remained the only superpower. And moreover, in the year 2012, a new conceptual framework called Non-Alignment 2.0 was put forward that for India to maintain its non-alignment policy, it should not take sides in the new Cold War between the United States and China. Now let us understand what has been the focus of the lead editorial. Now the focus of the author is that a new Cold War is emerging between the United States and its allies, and between the axis of China and Russia. And within this new global order of the new Cold War, the author has recommended that India should form a partnership with those countries that are beyond the influence of the United States, China, and Russia. Now, the reason why the author has recommended such a policy is that India should lead a new world order. And this new world order can be formed by partnering with like-minded countries that are beyond the influence of China, US, and Russia. And the author has also given examples such as IPSA or the India-Brazil-South Africa dialogue, the G15, among other initiatives in which India is a partner with other like-minded countries based on like-minded issues such as climate change, global governance, among others. Now hopefully up till here you have understood as to what has been the focus of the author in this lead editorial that a new Cold War is emerging between the United States and the axis of China and Russia. And in this new world order, India should form its own vertical world order by partnering with like minded countries on like minded issues. And for this, the author has recommended that the non alignment movement can become a driving institution in forming an India led world order. Now, with regards to your UPSC syllabus, this lead editorial and this subsequent analysis forms a part of your GS paper 2 in the International Relations section. And with this, we move on to our next article. Now, I've taken this article from the editorial page on page 9. Now, what this article talks about is the 242nd Law Commission report, which has suggested a legal framework. Now, this legal framework has been suggested for protection of autonomy, of choices and liberty of adults in taking matrimonial decisions, such as for marriage, but are being exposed to threats and socioeconomic deprivations, such as social boycott, among other deprivations. And in this regard, the Law Commission has drafted the Prohibition of Unlawful Assembly, Interference with Freedom of Matrimonial Alliances Bill of 2011. Now, this bill has been drafted with regards to the reports of honor killings in the society. Now, hopefully, up till here, you've understood as to what this article talks about. Now, let us further understand about the Prohibition of Unlawful Assembly Bill of 2011. Now, the first feature of this recommended bill is that it intends to curb social evil of caste councils, which are known as khap panchayats, interfering with and endangering the life and liberty of young persons marrying partners belonging to the same gotra or of different caste or religion. The second feature of this bill is that it prohibits the unlawful assembly or gathering of such members of panchayat or khaps to condemn the marriage and taking further action to harass or harm the young couple. The third feature is that the bill seeks to penalize honor killing with imprisonment or fine and upheld the right of adults to marry persons of their own choice without unlawful interference from caste panchayats or persons and relatives which are intent on harming the couple. The fourth point is that measures for prevention and protection of such people in such matrimonial alliances will be taken by the district magistrate or the SDM. These officials will be accountable for the failure on their part to take necessary steps to prevent unlawful assembly of such caste panchayats or to give protection to the targeted couple. Now, the fifth point is that any offences committed by caste panchayats or relatives will be tried by courts of sessions in the district presided over by the sessions judge as notified by the High Court. And the sixth point is that the suggested bill provides for steps to be taken for counselling and creating legal awareness in the society about fundamental rights of citizens with respect to right to choice. And the seventh and the last point of this suggested bill is that the Supreme Court in the Bhagwan Das case has held that honor killing shall be treated as rarest of the rare cases which would warrant the death sentence. Now, hopefully, up till here, you've understood the 7 features of the Prohibition of Unlawful Assembly, Interference with Freedom of Matrimonial Alliances Bill of 2011. And moreover, you should also understand that it is a suggested legal framework as given by the 242nd Law Commission report. Now, with regards to your UPSC syllabus, now the Prohibition of Unlawful Assembly Bill of 2011 first forms a part of your GS paper 1 in the subsection Social Empowerment, and secondly, it forms a part of your GS paper 2 in the subsection Mechanisms Laws Constituted for the Protection and Betterment of Vulnerable Sections. And with this, we move on to our next article. Now, we have taken this article from page 10. Now, the reason this article is in the news because Prime Minister Narendra Modi inaugurated the expanded Beti Bachao, Beti Padhao program. The Prime Minister of India also launched the National Nutrition Mission. So let us understand from your UPSC examination perspective the Beti Bachao, Beti Padhao program and the National Nutrition Mission. Now, the mandate of the Beti Bachao, Beti Padhao program is that the Government of India has introduced the scheme in 2015 and it seeks for the survival, protection and education of the girl child. Now, the objective of the Beti Bachao, Beti Padhao program is that it aims to address the issue of declining child sex ratio. Now, this child sex ratio is the number of females per 1000 males in the 0 to 6 age group. And this child sex ratio is declining in India, wherein as per the 2001 census, the child sex ratio was of 927 females per 1000 male. which has declined to 999 females per 1000 males as per the 2011 census. Now, the Beti Bachao Beti Padhao scheme is addressing this issue of declining child sex ratio through a mass campaign across the country. And this mass campaign is targeted at changing the values of the society and creating awareness about the issue. Now, the main features of this scheme is that it prevents gender biased sex selective elimination, meaning the selection in the form of knowing whether the unborn child is a female or a male is prohibited in India. And this scheme is trying to ensure that there are no illegal activities of female feticide. Moreover, this scheme is trying to ensure the education of the girl child. Now, the implementing agency of this scheme is that it is a joint initiative among the Ministry of Women and Child Development, Ministry of Health and Family Welfare, and Ministry of Human Resource Development. Now, the Beti Bachao Beti Padhao scheme will now cover 640 districts across the country, wherein earlier it was getting implemented in 161 districts. But as seen from the recent article also, the scheme has been expanded to 640 districts. And the cabinet has approved for this expansion for pan-India coverage, which would be funded 100% by the central government. Now, hopefully up till here, you've understood the mandate, the objective, features, the implementing agency, and the coverage of the Beti Bachao Beti Padhao program. Now, the understanding of government schemes is important from your UPSC examination perspective in both prelims and in mains, wherein a question was asked in 2016 mains examination in GS paper 2, which had asked for the main provisions and the status of implementation of a government scheme. Now, a similar question with regards to the Beti Bachao Beti Padhao scheme can be asked in your UPSC mains examination, wherein with regards to your UPSC syllabus, the Beti Bachao Beti Padhao scheme forms a part of your GS paper 2 under the social justice section. Now, let us understand about another scheme, the National Nutrition Mission. Now, the mandate of the National Nutrition Mission is that it would be an apex body that will monitor, supervise, fix targets, and guide nutrition-related coordination among ministries. The objective of the National Nutrition Mission is that it targets stunting, undernutrition, anemia, and reduce low birth weight. Now, the main feature of the National Nutrition Mission is that it will comprise mapping of various schemes contributing towards addressing malnutrition. What used to happen earlier, before this scheme was launched, is that every ministry, such as the Ministry of Women and Child Development, Ministry of Health, Ministry of Social Justice, among others, would have different schemes that would be focusing upon malnutrition. And what the National Nutrition Mission does is that it comprises all of these schemes under one platform. Now, the coverage of the National Nutrition Mission is that all the states and districts will be covered in a phased manner by the year 2019-20. The implementing agency of the National Nutrition Mission is the Ministry of Women and Child Development. Now, a question was asked in your 2017 prelims examination with regards to the objectives of the National Nutrition Mission. Now, apart from this, National Nutrition Mission also becomes important from your mains perspective with regards to a program that is intended to support and aid the vulnerable section. And now with this, we move on to our next article. Now, we have taken this article from page 11. Now, let us first understand as to why is it in the news. Now, the Union Cabinet has approved the Arbitration and Conciliation Amendment Bill of 2018 for introduction in the Parliament. Now, this bill would help in the facilitation for the establishment of an independent body called the Arbitration Council of India. Now, this bill is an effort by the Government of India to encourage institutional arbitration. Now, arbitration, in simple terms, is a process of settling of disputes between two or more parties by an impartial third party, which is not a judicial court and would intend for the settlement of disputes. Now, through this bill, the Government of India intends to make India a center of robust for alternative dispute resolution mechanism. Now, fully up till here, you have understood as to why is it in the news that the Union Cabinet has approved the Arbitration and Conciliation Amendment Bill of 2018 for introduction in the Parliament, which would help in the establishment of an independent body called the Arbitration Council of India. Now, the main objective of the government for the formation of such an independent body is that it intends to make India a hub for alternative dispute resolution mechanism. Now, the background to this Arbitration Conciliation Amendment Bill of 2018 is the Arbitration and Conciliation Act of 1996 was amended by the Arbitration Conciliation Amendment Act of 2015. But after this, a high-level committee under Justice Sri Krishna was formed, which had recommended that the Arbitration Conciliation Amendment Bill of 2018 is required to boost institutional arbitration mechanism, and it is based on the Justice Sri Krishna Committee that the Arbitration and Conciliation Amendment Bill of 2018 has been formed. Now let us understand the features of this bill. Now the features of the Arbitration and Conciliation Amendment Bill of 2018 is that the amendments will facilitate a speedy appointment of arbiters through designated arbitral institution by the Supreme Court or a High Court, and this would be without having any requirement to approach the court in this regard. Now this bill would also provide for creation of an independent body, namely the Arbitration Council of India, which would grade arbitral institution and accredit arbitrator. The third feature is that it would lay down necessary norms and steps to promote and encourage arbitration, conciliation, mediation, and other alternative dispute resolution mechanisms. The fourth feature is that it would evolve policy and guidelines for the establishment, operation, and maintenance of uniform professional standards in all matters relating to arbitration and alternative dispute resolution mechanism. Now the fifth point is that the Arbitration Council of India shall also maintain an electronic depository of all arbitral awards. And the sixth and the last feature is that the chairperson of the Arbitration Council of India will be a person who has been a judge of the Supreme Court or the Chief Justice or judge of any High Court or any eminent person. Now with regards to where it is placed in your UPSC syllabus, it is placed in your GS paper 2 under the Governance and Polity section with regards to the subsection Government Policies and Interventions for Development in Various Sectors and Issues Arising out of their Design and Implementation. And now with this, we move on to our next article. Now we have taken this article from page 5. Now the reason this article is in the news is because the Karnataka government has unveiled a state flag. And moreover, a proposal has been sent by the Karnataka government to the central government for approval for the state flag. And the decision of the central government is yet awaited, and therefore this news is in transition. Now we would not go into the political and the cultural debate with regards to the state flag. So what we'll do is revise the constitutional provisions that we had earlier covered from the perspective of the polity section. Now, Article 51A of Fundamental Duties says that it is the duty of every citizen of India to respect the national flag. Now the Constitution of India only talks about the national flag, and there is no mention for a state flag. So had the framers of the Constitution of India envisioned a concept of state flags, it must have found a mention either in the Constituent Assembly debates or in our Constitution. Now even the state list and the concurrent list under the 7th schedule contains no provision with respect to the state flag. And similarly, the Emblem and Names Act of 1950, Insult to National Honours Act of 1971, or the Flag Code of India 2002, there is no mention on a state flag. But the counter argument for this is that there is no law that forbids a state flag. And within that sense, Emblem and Names Act of 1950, the National Honours Act of 1971, or the Flag Code of India of 2002 contain no provision that forbids a state flag. And in that similar sense, in India, the Army, the Navy, Air Force, paramilitary forces also have separate flags. Now as you know, this news is in transition, but hopefully you've understood on where the Constitution of India stands on a state flag. Now with this, we come to an end in the analysis of today's paper. Now we move on to the question for today.